to my interpretation, and with all due respect, Professor Niken, I think that the Human Rights Court does implicitly say that not only was the citizenship taken away in an illegal way, in an illegal form, because due process of the law was indeed violated. Also, the right of opinion and the right to press, but also implicitly the court says that discrimination in human rights is only, let's say, legal or valid when we are dealing with political rights, because that's the real sovereignty that a government or a country has. Obviously, each country can establish limitations for foreigners to vote or to participate in unions or to participate in political parties. But I also wanted to add that the European Human Rights Court has also developed this principle. Discrimination in regards to human rights between foreigners and nationals is not valid. I mean, you cannot discriminate dealing with free enterprise. You cannot discriminate dealing with the right to work. Our constitutional tribunal, for example, has stated that it is unconstitutional provision from our laboral code that says that inequality of conditions, the one should prefer the national worker and not the foreign worker. So, I mean, that's my interpretation of what implicitly, to me, the Human Rights Court said, also related to what the European Human Rights Court has also issued as legal precedents.
So that brings me to my next question, and that is, you make application to an agency. I assume the agency's duties to discharge its functions as a matter of law and regulation is not delegable. They cannot avoid doing that. They must make a decision, correct?
Correct. Indeed, Article 66 of our General Administration Act states that public duties are undelegable, and well, yeah, the answer is yes.
Okay, so after, you've taken great care to draw a distinction between before the issuance of an EV and after the issuance of an EV. And I want to make sure I understand the consequence of that distinction once the permit or the EV has been granted. Does it create rights? You've said it creates legitimate expectations, but does it create legal rights in the holder of that EV when the agency has given it in response to a plan?
Sure, that is why the Constitutional Court and the Procuraduría General de la República, and here I want to make a clarification. We tend to translate Procuraduría General de la República as Attorney General. It's not quite the Attorney General. The Procuraduría is like the General Counsel for the government. The Procuraduría has established that when you are going to declare EV as null and void, you have to follow the due process of the law.
Okay, so let me back up then. Here, we never had a situation where a permit was declared null and void. We had situations where they were injuncted. So do I understand the fair balance of your testimony is that the wrong remedy was used by the agency? It should have been declared null and void rather than injuncted? Is that the principal thrust of your testimony?
Exactly.
All right, so if that's the case and the wrong remedy was applied, tell me, under the 15-day concept that we've been discussing, whose duty is it to come forward and point out that the wrong remedy took place? Is it the agency, who is the expert under the public administration in this, that's supposed to revise itself? Or is it the person whose rights were affected in the EV that was injuncted that has the duty to come forward and fix the problem?
Both,
Both can, but who bears the principal responsibility?
the responsibility is of the agency, and it is expressly stated in the General Administration Act, Article 194, more or less, which states that if a wrongdoing from the administration has been detected, then the administration, no matter how much time it has gone by, is obligated to annul its acts, resolutions, and conducts.
So then, is it a fair summary of your testimony for me to take away that your view is that regardless of whether the EV was properly granted, once an EV was properly granted, the duty for ending that grant through a remedy of ordering it to be null and void lies with the agency, and that is non-delegable? Is that a correct summary?
Exactly. Administrative acts are deemed valid until they are declared null and void by the procedures that the legal scheme states. Meanwhile, if you have not annulled or declared them null and void, they have to be applied.
All right, so let me press you a bit on that. You're saying that even if the injunction was not rescinded or dissolved in any way, that the public administration that issued that is in violation of its own rules and regulations? Is that what you're saying?
I'm sorry, could you repeat?
Yeah, I'm just trying to push you, and I'm going to push on the other end in a minute, to see how far your logic takes us. Are you saying that even if an injunction was issued by the expert agency and it should have been declared null and void, because it applied the wrong remedy, is that agency responsible in damages for having used the wrong remedy? Is that what you're saying?
Of course. Because by doing that way, by acting wrong, it has paralyzed or it has freezed the rights of the developer without following the legal procedure. Once an agency has an empowerment and has been their door has been knocked by the citizen for them to empower their duties, then public agencies become co-responsible. What I said it at the time when the easement was executed, it was a reasonable interpretation because there were at least 3 resolutions by the SETENA that exempted VAs from certain kind of projects, and I would say that delegated the acknowledgement of the project to each of the municipalities to determine if in fact it needed VA or it did not. And under that reasonable interpretation was that that developers decided or interpreted that just for the execution of the easements, not for the execution of the project itself or the construction itself or the initiation of the activities, it was not necessary a VA. So they decided to submit their application to the municipality, who also determined that there was no need of a VA. So my position is that it was a reasonable interpretation that was in fact confirmed by the municipality, by IMBU, at least by those 2. Also bear in mind that the municipality had made inspections all over the place, all over the project, and that SINAC had already released its reports stating that there was no wetland in the property. So I think it was a reasonable interpretation based on resolutions that were in place during that time by SETENA that exempted certain kind of projects from going to a VA, and that there were, and this is to me the most important part of all this case, there were not one, but several reports from SINAC, which is empowered to overview wetlands, that said there are no wetlands here.
And this would, because one of the issues also in dispute is whether or not these EVs that had been issued under lack of information that had been disclosed by developers. This is, one of the parties alleges, naturally the Republic of Costa Rica alleges that it was the responsibility of developers to have disclosed the existence of whatever information there was, and whether these could be flooded areas that should not be considered as wetlands, but somebody could take the position that they were, that this is the information that should have been disclosed. What your testimony as legal expert is that it was the responsibility then of SETENA, SINAC, and even the municipal authorities to make the inspection and ascertain whether or not there was a wetland. And the fact that they did not, then this was a, following a response you gave to Mr. Baker, this was an acquired right of the developers. Did I interpret this correctly?
Yeah, and moreover, what information was missing on the part of the developer if SINAC had issued at least 3 reports in which it said there were no wetlands? So what is the lack of information? I mean, the public entity that is empowered to overview wetlands had said there is no wetland. And from my attorney point of view, I think it is not easy to determine where is a wetland and where there is just a flood. I mean, my backyard sometimes floods and it is not a wetland. So it is not an obvious.
I agree. I don't have, I think you and I as lawyers can apply the terms of the regulations that establish what the 3 elements under Costa Rican law that are required to deem that there is a wetland. I have one last question, and this deals with what I construed you to say, that the Constitutional Court in Costa Rica has ruled on the subject of the treatment of nationals and non-nationals in a different manner. And perhaps this was during your presentation yesterday evening or earlier this morning, but I think it was the former, where at least I understood you to say that even the requirement of having a majority of Costa Rica national participation in the capital stock of a company in a terrestrial maritime zone should be deemed to be unconstitutional. Was this your position? Is it your argument that if an authority should come in and say that it was unlawful for somebody like Mr. Aven to hold more than 50% in the capital stock of La Canícula, that should be treated by the constitutional courts in Costa Rica as unconstitutional? Because an American citizen, or Italian for the matter of whatever nationality one would have, should not be treated differently than a Costa Rica national?
To me, that is unconstitutional because we are dealing here with free enterprise and other fundamental rights. And I have to make 2 precisions. First of all, the Constitutional Chamber has been well, or the parties, certain parties have submitted for constitutional writs against this article. The constitutional,
Which article, I'm sorry?
the article that states that Costa Ricans have to have
for the-
majority
for-
in the
for
of the
the-
shares.
ZMT, la zona
Exactly,
marítimo terrestre.
CMT.
Okay.
The Constitutional Chamber has rejected, but for procedural reasons. So the Constitutional Chamber has not issued any, at least not from 2000 to today, has not issued any ruling on that. And it's important, remember our civil code states that that the laws have to be interpreted in the context of history. If you study Costa Rican CMT concessions, we have Marriott hotels, we have Four Seasons, we have Spanish hotels. Do you think that Costa Ricans are really the owners of the 51% of the shares?
Well, remember that many hotels only manage rather than own
Yeah.
the asset.
But-
Many of these hotel chains manage, not own, because of capital reasons.
Exactly. But in many of those cases, they are really the owners. At least the experience I have with my clients, those two, one of those it's my client, but not the Four Seasons, but you have to interpret the law in the context of history. That perhaps in 1965, when the sovereignty of the countries was very empowered in people, may have had some rationale. But today, we are a global world in which there is no rationale in having discrimination amongst foreigners and Costa Rican citizens. I mean, not even in political rights at a local perspective.
Yeah,
If you live,
that's outside of the scope of
Okay.
this arbitration.
sorry, I'm a little passionate about that
Thank you very
topic.
much. Is there any?
Yes. Article 84 states, duties of the technical secretariat. The duties of the National Technical Environmental Secretariat are the following. D. Carry on the in situ inspections corresponding the corresponding in situ inspections before issuing its resolutions.
This describes the competencies, right? So that's funciones, right? It does not say what the obligations of the authorities are. Do we agree on this?
On administrative law, we talk about potestades or competencies.
That's right.
Obligations are for particulars. So when you have precisely Article 66 of our Administrative Act states that competences or empowerments are indelegable. So a competence means, because of the rule of law, because of the legality principles, means an obligation by the government agency.
So, yeah, and we will probably have to disagree on this because potestad is what an administrative body can do, not what it shall do. And I believe wouldn't you say that the formulation would be different?
Well, you can also read Article 13.0 of Executive Decree 36153, that it's the reorganization of SETENA, in which it also states that it is an obligation, it's a must.
Let's move on. So